And
Yeah, so attempted R&O, the felony would be dropped and plead to the OWI?
yes, my client has
So
signed.
really, yep, so really 2 misdemeanors, the felony is dismissed entirely.
Yes, I have to point out to my court, well, that's taken no contest plea. My client was injured in Afghanistan. He has a brain injury. He's 100% disabled. So his
Okay.
memory of weapons is uncertain. Will stipulate that the police report can be used. He's read it over to refresh his memory, but he recalls nothing.
Mr. Tarango was just on a Zoom with us on some other cases we had moments ago, and he got a pretrial Zoom in his own Zoom room, so he left. He said he'd join us again, but he did send to the court the pre-exam conference form on your case with Mr. Ayers, on the attempted R&O and the OWI. Mr. Tarango's back now. So if you want to go forward on that, yep. If you want to go forward on that today, and Mr. Tarango, Mr. Krupp had indicated that his client would be pleading no contest to the 2 cases because of a closed head injury he suffered previously and has no recall of the case.
He's 100% disabled.
I have no objection to that, Your Honor.
Okay.
That has been brought up. I do remember speaking to Mr. Krupp about it. He did inform me that his client had some military service in which he had some injuries as a result of it. So I have no objection to the no contest.
Okay.
Judge, I sent a copy of the medical reports to the court.
Okay, that's fine. So Mr. Ayers, let me just talk to you a second if I could. I'm Judge Sara Smolenski, and this is the time and place for what was called the probable cause conference on the felony. Now Mr. Krupp has worked out an agreement that if you decided to plead to an attempt R&O, a 1-year misdemeanor up to $1,000 fine, and an operating while intoxicated that's often referred to as like drunk driving, a 93-day misdemeanor up to $500 fine, there'd be no felony case. It would be dismissed entirely. We've talked a bit about pleading no contest, and no contest is treated like pleading guilty. For purposes of penalty, a conviction on your record, no contest is treated like pleading guilty, but you don't say anything. And the police report, while it may be accurate in some areas, in many areas, we go by the police report to support whether there is sufficient evidence to show a crime was committed. So the no contest is your right. So is your right to plead not guilty. Actually, everybody has the right to either plead guilty, not guilty, or no contest. And no contest is used in situations like yours, where you have any type of disability that could affect your memory. Sometimes no contest is used when people are involved in a civil lawsuit that could be happening after the criminal case. At any rate, you have the right to plead guilty, not guilty, or no contest to both cases, have the right to have a trial in front of a judge or a jury, have the right to have an attorney. Mr. Krupp is here, certainly more than capable of representing you. If you wanted to have a trial, Mr. Ayers, you could bring in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you, and you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. If you do go forward today and enter a plea of no contest, and I accept it, then there is no trial at all, and we move right into the penalty phase. Are you right now, Mr. Ayers, on probation or parole anywhere for any other cases?
Yes, Your Honor, in Wyoming.
And the Wyoming case is what?
It was an assault charge, Your Honor.
And do you have probation on that right now? Is the case done, or is it still what we call pending?
I do have probation, Your Honor.
Okay. So the date of our incident is October 7. If you were on probation in Wyoming then, it could be a probation violation where the Wyoming court could take further action against you on their case. Do you understand that, Mr. Ayers?
I understand.
He is
If there
reported,
was, go ahead.
he's reported to them this case.
Yes, sir.
Yep, I'm sure they would know about it. It's good that he told them. If there was something you didn't agree with that happens on this case, or anything that I did or do that you don't agree with, you're allowed to appeal to the circuit court, and the appeal can be taken within 21 days after being sentenced. Now, in this case, because it was just a couple of weeks ago, we don't have an alcohol assessment yet, and that's required in every one of these cases. So if you go forward today, I don't sentence you today. Do you understand that, Mr. Ayers?
Yes, Your Honor, I understand.
Okay. So if we're talking about two different cases, attempted resisting and obstructing a police officer from October 7 near the US 131 Expressway and M6, how do you want to plead to that charge?
No contest, Your Honor.
And when you're pleading no contest, you understand that that's treated the same as pleading guilty.
Yes, Your Honor.
And as to the charge of operating while intoxicated, operating a vehicle with too much alcohol in your system, how do you want to plead to that?
No contest, Your Honor.
And we're talking about the same incident, October 7th, and I'm referring to a police report that I've never looked at before, that I'm looking at right now, where on Wednesday, October 7, 2 weeks ago today, the police were dispatched to a one-car crash. They saw Isaiah Ayers, who was actively fighting with the EMS personnel. Mr. Ayers was arrested and lodged at the Kent County Jail. A warrant was taken to get blood from his body, and they did give you a blood test to see how much alcohol was in your system. Now, Mr. Krupp, when you've reviewed the case, have you ever heard or gotten the word as to what the blood test results were?
No, we haven't, Your Honor. It takes a while.
Okay. And when I'm looking at the car accident, they said they were dispatched to US 131 ramp, westbound M6. It was a single vehicle crash. When the police arrived, the EMS people were right there, and there was a physical altercation with the driver. The EMS personnel were actually holding Mr. Ayers down, and he was actively resisting them. He was being held to the ground by, it looks like, 2 firefighters and 2 EMT personnel. And the entire time it said Mr. Ayers was actively resisting the EMS. His hands were going behind his back, and as the officer was attempting to pull your arm from underneath him, you began fighting with the officer, resisting and pulling your arm away. The deputy, probably with help of these other people, was able to secure your hand in a handcuff. Throughout this, they said they were giving you loud verbal commands to stop fighting and stop resisting, but they said you really were not complying. With the help of the firefighters, they got you on your stomach. I'm sure it felt like they were just totally tackling and on top of you, but they were trying to get your arms in handcuffs. They said your eyes were bloodshot and glassy. You had an extremely strong odor of intoxicants coming from your person. They said it appears that you had urinated yourself. They said that they interviewed another person that was there. He's an EMT. He was dispatched to the crash because of injuries. The injuries at the time were unknown. Mr. Martin stated that once he arrived, he saw Mr. Ayers seated in the driver's seat, and he was the lone occupant. Mr. Martin stated he took Ayers to the ambulance to medically evaluate him, but once in the ambulance, Mr. Ayers stated he was good. He was just going to get in his car and drive away. Mr. Martin advised that his car was not drivable from the accident and told Mr. Ayers he couldn't drive. Mr. Ayers stood up from the cot. He leaned towards Mr. Martin and just shoved him backwards by pushing him on his shoulder. Mr. Martin said Mr. Ayers then attempted to climb into the front cab of the ambulance, and he was trying to get into the front cab feet first, which was difficult. Martin stated he believed that Mr. Ayers was about to kick out the windshield, so he put Mr. Ayers in a headlock to actually prevent him from damaging the front of the ambulance. Another EMT then pulled Mr. Ayers to the outside of the ambulance, where then 2 firefighters assisted in trying to get control of you, Mr. Ayers. It must sound like almost an out-of-body experience when I'm talking about what happened here from their experiences. They took you to the Kent County Jail. They drew blood from your arm by a nurse at the jail. And I don't think they ever gave you a breathalyzer. They had to get a search warrant from the magistrate, and it was around 1 o'clock in the morning when they did that, shortly after getting you to the jail from the accident scene. When you're involved in the resisting and obstructing with the officers and with the EMT and with the firefighters, that's why they charged you with this offense. The OWI is operating under the influence of alcohol where you're impaired enough that you cannot control your vehicle and had the accident. We'll get the blood results through the course of your case when you're on probation to us. And recognize that with both your closed head injuries that you've suffered through the course of your military service and your alcohol issues, it's a lethal combination. So right away, we're going to order you no alcohol whatsoever. We're going to set this up for sentencing, and I'm guessing that by the time we have the sentencing on this, Mr. Krupp, we'll have gotten the report back to know exactly what the blood test result.
Good.
I'm fairly confident it's going to show it was over the legal limit, which is 0.08 or above.
I'm sure, Your Honor.
Yeah. So I'm asking you, Mr. Krupp, whether you believe the court has complied with the no contest plea on both the OWI misdemeanor and the amended charge of the misdemeanor attempted R&O.
Yes, it has, Your Honor, and we'll stipulate to the facts.
All right. So I don't think there's going to be any restitution that we're focused on. I don't know about the car accident itself. I'll probably learn more about it. I don't know whether there was any signage or road commission, Department of Road Commission, like, signs that were damaged or guardrails that were wrecked. I really don't know what the car hit, if anything. We can look into the restitution, but we need to have you have an alcohol and drug assessment. That's required by law in every case. They'll set it for sentencing, and we can look into the restitution if there was any. As far as the damage to your car, Mr. Ayers, you're going to have to work with the insurance company on that.
Insurance, Your Honor.
Yeah, that took care of everything. Yeah. You had a huge amount of bond posted. You had
he hit a guardrail, so there might be.
A guardrail?
Yes, Your Honor.
Okay, we'll check into that. And then sometimes your insurance covers that as well, Mr. Ayers. I just don't know that yet. It looks like there was a pretty hefty cash bond that was posted. Is that by you or by your family?
That was by me, Your Honor.
Yeah. We hang on to that until we're finalized with the case, but that would be applied towards any fines you get.
Thank you.
So right now, we'll get the assessment set, we'll get a date set for sentencing, and Mr. Krupp will be in contact with you to set that up. The sentencing will again be done by Zoom, just like this, but we'll get a hold of you, Mr. Krupp, so you can get a hold of Mr. Ayers and we can work out the date with you, okay?
Should I send him out to probation?
Not at this point. right now, because there's not a sentence date, there isn't a final sentencing yet.
Okay.
Eventually, when he's sentenced, then he'll be meeting with probation. Most of that is gonna be done remotely.
Yeah, where you want him to do the alcoholic assessment?
Any of the programs that we use through our court, which are about 6 different groups strong, you probably know some of them, you can pick one.
I have that list, Judge. Judge, I have the pre-exam conference form signed by myself and my client and the rights form. Should I mail that to the court?
Yeah, you can send that in, either email or regular mail is fine. Mostly the advice of rights form, not so much the other one.
Okay.
All right?
Thank you, Your Honor.
All right, we'll be in contact with you both. Thank you, Mr. Ayers. Thank you, Mr. Krupp.